The extension of the XRP litigation is something that Judge Torres considers to be both adequate and fair. Ripple Labs and the United States Securities and Exchange Commission have filed a lawsuit in federal court in an attempt to prevent the general public from gaining access to discovery papers that are associated with Ripple Remedies. Among these records are comprehensive financial statements as well as XRP institutional sales that took place after the complaint was submitted. A federal judge has given his approval to new revisions to the timeframe as well as redactions that were made to the document concerning remedies. As stated in a document submitted to the court on March 20th, in response to a joint application submitted by Ripple Labs and the SEC to resolve the parties' issues, Judge Annalisa Torres granted approval to an order that addressed concerns surrounding the sealing of the future briefing pertaining to remedies. According to the reporting of Cunning Teas, Torres was of the opinion that it was acceptable to extend the XRP litigation in accordance with the revised dates. Despite the fact that the plan will contain some redactions that will conceal substantial sales from the XRP army and the cryptocurrency community, the attorneys who represent the plaintiffs and defendants have expressed their expectation that the plan will make it possible for the parties' pleadings to be released in a timely and public manner. In spite of the fact that the dispute was resolved when it was determined that XRP did not qualify as a security analyst, the Securities and Exchange Commission and other parties are continuing to concentrate on XRP transactions. The continuing dispute between the Securities and Exchange Commission (SEC) and Ripple Labs, which is also being managed by US, is one factor that may possibly have an effect on the price of XRP. Judge Torres has the authority to assess and make a decision on the Securities and Exchange Commission's SEC certifications about the penalty for the sale of XRP to large investors in response to a complaint, under the assumption that the attorney's forecasts are proved accurate. In the event that Ripple and the SEC are able to negotiate a settlement, the case will continue for a number of more months until Judge Torres makes her final decision, which is likely to take place at the beginning of the next year. In a similar manner, the time it took Judge Torres to issue a summary ruling on July 13, 2023 was longer than expected. Following the filing of the complaint, Judge Torres made a determination regarding what constitutes fair, full financial information and postings. Examples of these disclosures include the materials that the United States government has discovered. The Securities and Exchange Commission and Riverside Labs have filed a petition in federal court to prevent the public from having access to records that pertain to the extension of the XRP case and Ripple's remedies. A judge at the federal level ordered that the revised schedule and any redactions be disclosed in the document that pertains to the remedy application. The remedy-related briefing has been ordered to be sealed as Judge Torres has issued the order. Ripple Labs and the Securities and Exchange Commission (CC) have submitted a joint application, and Judge Annalisa Torres has issued an order to rule on sealing issues relevant to the upcoming briefing on remedies linked to the application. According to a court filing that was filed on March 20th, Torres believed that the issues between the parties may be handled in a reasonable manner by utilizing the new days for the extension of the XRP case. According to Cohen Jeep, the attorneys for both the plaintiffs and the defendants are in agreement that the plan would provide for fast public access to the files of both parties, with certain redactions being made. It is highly likely that the cryptocurrency community and the XRP army will be kept in the dark about significant difficulties until Ripple the SA and other third parties figure out how to redact the information that is required. Despite the fact that the majority of experts believe the case has little merit, the majority of attention is still being paid to the sale of XRP as a result of Judge Torres' decision that XRP is not a security. The opening brief concerning remedies was submitted by the Securities and Exchange Commission on March 22nd. Additionally, any additional declarations and exhibits were submitted under seal at the same time. The Supreme Court made a version of the brief that had been redacted available to the public on March 6th. This version had been requested by both parties as well as third parties throughout the case. As an immediate consequence of this, Ripple and the SEC have rescheduled the dates of the litigation. It appears that the discussion and conflict will continue beyond the date of May 6th. In line with Section 5 of the United States Securities Act, the Securities and Exchange Commission (CC) could file objections to Ripple and other unanticipated submissions, which would result in a further extension of the statute's duration. In the event that the anticipated settlement accord between Ripple and the SEC is not able to be achieved, Judge Torres may also take into consideration the possibility of issuing an order regarding the claims made by the SEC regarding the penalty for XRP institutional investor sales that occurred after the complaint was filed. On May 6th, Ripple will submit a version of its opposition brief that has been redacted along with providing evidence in support of its position, and the SEC will file its response brief in a sealed envelope. The second summary judgment that Torres is requesting will be issued on July 13th, 2023, and it will state that XRP is not a security. In light of the fact that neither Ripple Labs nor the United States Securities and Exchange Commission are asking the public disclosure of material information concerning remedies, This is a significant development in the ongoing disagreement that exists between the two organizations. The most recent court filing indicates that Ripple Labs and the United States Securities and Exchange Commission have jointly moved to seal critical information that is contained within the briefing that is related to remedies. Attorneys for both the plaintiffs and the defendants have urged Judge Torres to give the plan the go-ahead, stating that it will ensure that the public has quick access to the PRI brief without particular redactions. This is due to the fact that the verdict and conclusion date of the drawn-out lawsuit between Ripple Labs and the SEC are still unknown. On March 22nd, the Securities and Exchange Commission (SEC) submitted the opening brief related to remedies under a seal. 2025, in addition to any other declarations or exhibits that may be required. The parties have proposed a time frame for redaction in response to the market emotion that was conveyed in response to the opening brief on remedies that was expected on May 6th from the Securities and Exchange Commission. Following the parties' and third parties' requests for the redactions, a meeting has been planned to discuss the redactions in order to identify them. On March 26th, the Securities and Exchange Commission (CC) made certain copies of the brief and the opposition brief from Ripple available to the public. The 22nd of April is the specific date that these documents must be submitted by. In the next days, it is anticipated that the parties will get together in order to present a revised reply brief. The 20th of May is the deadline for the parties and any intervening third parties to submit written motions opposing depositions on the cessation of filing details. Because of this, it is anticipated that the legal proceeding will continue for a number of further months, and it is anticipated that a final verdict will be issued sometime in the month of May in the following year. The overall cryptocurrency market has experienced a fall from its recent highs, which has occurred in the meanwhile. This is what the market capitalization indicates. XRP is the price of the coin that is responsible for fueling the 7th largest cryptocurrency ecosystem. Ethereum's price also experienced a significant drop, falling from roughly $4,000 to $3,500, or a 15% decrease. XRP experienced a precipitous decline from its all-time high of 74 cents in 2024. The price of XRP has been consistently stable at 58 cents. It's possible that the pattern is still going strong, considering that Ripple and the SEC are both getting closer and closer to their respective deadlines. An attempt has been made to make projections regarding the price of XRP. There is a possibility that Ripple and the Securities and Exchange Commission will exert some influence, given that both parties are approaching significant deadlines in the near future. If a United States regulator decides to close its doors to other parties, it may have an effect not only on the Securities and Exchange Commissions, but also on XRP. The official documents will remain under lock and key until the 24th of April, at which point they will be made accessible to the general public. The Securities and Exchange Commission (SE) has until the 7th of May to deliver its case, and legal experts have stressed the critical significance of these activities. In addition, beginning in the month of May, a portion of the content will be made accessible to the general public. At this point, that is all.